All right, we're going to go ahead and get started now. Again, good morning and thank you for joining us today. My name is Carrie Simmons and I am a regional planner at SANDAG and I'm the project manager for SANDAG's Housing Technical Assistance Program. Today, our technical assistance team is bringing to you a webinar on understanding density bonus law. The webinar will be led by our technical assistance team from Ascent, Matt Gelman, and Rebecca Pope, as well as Gabrielle Janssens from Goldfarb and Littman. In the spirit of collaboration, I also want to note that today's webinar will be joined by staff in the audience from both the San Diego region as well as the Bay Area region, and want to thank everybody again for participating and collaborating in this webinar. A few housekeeping items before getting started. I wanted to share that the webinar will be recorded and all materials from the webinar will be posted on sandag.org and will also be shared out to all registered attendees. And for any questions that you might have throughout the webinar, we've enabled the Q&A feature. So go ahead and put any questions you have there. And our team will be facilitating answering those questions either live at some of our question breaks that we have or in the chat. So with that, I'm going to go ahead and pass it over to Matt to kick everything off.
Good morning, everyone. I'm Matt Gelman from Ascent. I'm a senior planner and project manager for the technical assistance team. Pleased to be with you all and facilitating the webinar this morning. Density bonus law is something we as a technical assistance team have received a lot of questions about. And we're pleased to try to answer all of your questions as best as we can through the presentation as well as the Q&A and any discussion we have. We're going to start with an overview of density bonus law. Then we'll talk about project eligibility and affordability requirements, talk about applying density bonus, and then we'll get to, I think, what will be of interest to most people is a section on incentives, concessions, waivers, and parking reductions before the last section of the presentation on implementation considerations. Thank you to everyone who registered and answered the survey questions for the webinar. We did look at a lot of the questions in developing the content, so hopefully we've addressed many of those through the presentation, but as Carrie noted, please provide your questions in the Q&A feature of Zoom, and we'll do our best to answer those. My favorite question was, where is the line for density bonus? I'm not sure if anyone's found that yet. It keeps evolving, and it's a tough line for planners to find as we waive regulations and development standards for projects. So we're here to talk about density bonus law and give you the best information and guidance that we can, but we know it's tricky when projects come through, and we'll do our best to answer your questions. So without further ado, I will turn it over to Gabrielle.
Hey, good morning, everyone. My name is Gabrielle Janssens. I'm a partner with the law firm of Goldfarb and Littman. We primarily work on affordable housing, both advising developer clients from start to finish developing affordable projects, and we also do a lot of work with cities, counties, and SANDAG, advising on all of these legal changes that happen every year to all the housing laws and how it impacts processing applications for housing development projects. Really quickly, I'm going to give a disclaimer that we're not providing any legal advice today, and we encourage you to speak with your legal counsel if you have project-specific questions. This will be a high-level overview of density bonus law, and I hope that our questions can stay at that general nature as well. We will not be touching on any project-specific questions, but if you have general questions, please do put those in the Q&A. So next slide, please. So what is density bonus law? It is a law that provides for and tries to encourage the development of affordable housing, and does so by providing benefits to those who provide such affordable housing in their development projects. So if a developer provides affordable housing, certain other types of housing as well, they can receive an increase in the density for the project, as well as incentives, concessions, waivers, and reduction in parking. And we will touch on all of these topics during the course of this webinar. Next slide. So density bonus law has been around for a long time, but there have been a lot of changes in the recent past. So starting, as you can see on the slide, in 2018, there were some changes related to FAR instead of density bonus. In 2020, there was an increase in the maximum density bonus permitted, as well as adjustments to affordability thresholds to qualify and reduction in parking standards. In 2021, student housing was added. In 2022, shared housing projects were added to the law. And also in 2022, commercial density bonus eligibility was added. Next slide. And then 2024, some residential care facilities for the elderly content was added. And then last year, more changes related to FAR. And I think a big one has to do with excluding hotels and transient lodging from density bonus. And this is also was a common theme in 2025 as these hotels and transient lodging was also removed from the Housing Accountability Act, but that's not what we're talking about today. So changes to density bonus law started as bigger changes, and as the years have gone by, they've been more refining and nuances related to density bonus, to the density bonus law. So not as big of changes, but still things to be mindful of and aware of as the laws do get tweaked every year. Next slide. So we're going to start by talking about what makes a project eligible and the affordability requirements for that. So in order to be eligible, a project needs to have 5 or more residential units. They need to specify what percentage of the project will be affordable and the affordability level, and that will dictate how much density bonus and how many concessions a project can receive. And then there's certain exceptions like senior citizen development, which do not need to provide affordability. And then we're not going to cover in this webinar replacement housing requirements, but there are some requirements related to replacing units if they need to be demolished for the project to go forward. Next slide. So on this particular slide, you will see the breakdown of affordability percentages. So a project that provides very low income units, they need to provide at least 5% of the base unit at a very low income level, can receive a density bonus as well as incentives, waivers, concessions. If the project is providing low income units, at least 10% of the base units need to be low income. For moderate income as well, at least 10% needs to be moderate income. There are special provisions for projects that are 100% affordable, excluding a manager's unit. And in those projects, 80% needs to be, or at least 80% needs to be affordable to lower income households. And there is an option to provide up to 20% of the units to a moderate income level. And then a few other special projects that fall into density bonus law have to do with senior housing, housing for transitional foster youth, disabled veterans, student housing, condominium conversions, child care facilities, land donations, and certain commercial developments. One thing to note is what is considered at these income levels. So very low income households are considered to be up to 50% of the area median income. Low income households are up to 80% of area median income, and moderate income are considered to be up to 120% of area median income. And if we go to the next slide, this is the calculation that was published by HCD in 2025 for area median income for the county of San Diego. So this is what the calculations will be based on. We look at the AMI as well as the household size, and that's how you figure out what a household might qualify, what income a household might need to qualify for one of these affordable units. Next slide. So then we look at what is affordable rent. So the units that are provided for affordable households need to be provided at either an affordable rent or, if they are for sale units, at an affordable housing cost. So for very low income households, that is 30% of their AMI is what can go towards rent. That's what's considered affordable. For low income households, it's 30% of 60% AMI, which is considered affordable. And then for moderate income, it's 30% of 110% AMI. And you might notice that the percentage of AMI for the rent is not quite the same as what is considered for eligibility. So that's just one thing to keep in mind. Also, the affordable units must be made affordable for a term of at least 55 years. That term can vary slightly and be a bit longer if a local code provides for something different. So next slide. So there is more than one way to define affordable rent, and this can get confusing. But generally, for density bonus law, we rely on the Health and Safety Code definition of affordable rent, and those are the rents that we just went over a moment ago. However, if a project is 100% affordable, there is an option to use the California Tax Credit Allocation Committee rent levels, and those are slightly different than the Health and Safety Code rent. So a reason why a project might request this calculation instead is that in many jurisdictions, the TCAC rent is slightly higher than the Health and Safety Code rent. There is also the fact that a lot of the 100% affordable housing projects are relying on tax credits, and so it just makes it a little bit easier to track and monitor the rents that they need to charge the tenants if they can be using tax credit across the board as opposed to calculating different rents for different units. All right, next slide. So affordable housing cost is the cost to make a unit affordable for purchase. And that is 30% of 50% for AMI for very low income households, 30% of 70% AMI for low income households, and 35% of 110% AMI for moderate income households. Unlike for rental households, there's not a regulatory agreement that's recorded on title for requiring a term of 55 years. This is done through cost share agreements instead, and that is an agreement between the city or county and the eligible purchaser of the property. And what's in those agreements tends to vary by jurisdiction, but generally what is needed is that the public agency can recapture the cost or what's considered the local subsidy, and that's the amount that the household basically did not have to pay to obtain the unit. So the difference between the affordable cost and the market rate cost. And the exact calculation varies by jurisdiction. Next slide. Okay, so now we're going to talk about applying density bonus. So on the screen, you will see a chart of varying amount of percentage that a project might provide for an affordability category and the amount of density bonus that they might receive for having provided that amount of affordability. There is a longer, more detailed chart in the statute itself, but this is the general, this fits on this slide and you can actually read it. So I'm not going to go over each of the percentage categories, but it's there for you if you would like to take a look. So next slide. And then I also wanted to note that a project is not required to request additional density. So even if it does provide the affordability and is eligible to receive a density bonus, it is not required to take that density bonus and increase the density of the project. So there's a couple other density categories. So senior citizen housing can have a 20% density bonus. Foster youth, homeless, disabled, veteran housing receives 10% or can provide 10% very low income for a 20% density bonus. And then student housing, 20% low income can receive a 35% density bonus. Next slide. In recent years, a new concept was added to density bonus law, and that is what we're calling, I think I've heard it called different things, density bonus stacking or a double bonus. And in this particular case, is where a project provides a density bonus that we just talked about, and then they provide an additional percentage of lower income units to receive an additional density bonus. And those are in the categories of low income and moderate income. And on the screen is a table that shows you how much affordable units need to be provided to receive that additional density bonus. A couple of things to note is that the resulting housing development cannot restrict more than 50% of total units, and total units in the statute is defined as the base unit, so it's a bit confusing. And then there's a minimum amount that they need to be restricting prior to this bonus, density bonus. So it needs to at least be 24% of the units for lower income, and then you can add on one of these percentages, or 15% for very low income, and then again add on one of these percentages, or 44% for moderate income, and then add on one of these percentages if you provide additional affordable units. So next slide. There's also additional density bonuses in the statute that are provided for including childcare facilities, providing a land donation, or certain condominium conversion projects. Okay, so layering with local inclusionary requirements, many jurisdictions have an inclusionary ordinance that requires a certain amount of the units in a project be provided at a particular income category. So those lower income units that are provided to comply with an inclusionary requirement can count towards the percentage needed to obtain a density bonus. So those are not additional affordable units. They all count for both purposes. And there was a case a handful of years ago called Latino Unidos versus County of Napa that made this requirement clear. Next slide. Okay. So there's some additional incentives if the project is located within a half mile of public transit. And these are limited to 100% affordable projects. So normally 100% affordable project can receive up to an 80% density bonus. If they're within a half mile of a major transit stop, the density is unlimited. They can make a project be as dense as they would like. A major transit stop is defined as a site that's containing either an existing rail or bus rapid transit station, a ferry terminal served by either a bus or rail transit service, or the intersection of two or more major bus routes with a frequency interval of 15 minutes or less during morning and afternoon peak commute periods. And I think that 15 minutes might have recently been increased to 20, but I would need to double check that. And then if the affordable housing project is located within a half mile of a major transit stop, it can also receive a height increase of up to 3 stories or 33 feet. So that's an added bonus for being an affordable project near transit. Okay, next slide. So a developer needs to choose from one of the density bonus categories. We just went over all the different categories, so they need to select one. And then on top of that, there's the additional density bonus opportunities. So those were the stacked ones that we talked about. And then also, for example, a childcare facility would be an additional bonus if that is provided in the project. All the density calculations need to be rounded up. So if you wind up with a fraction of a unit, that would be rounded up to the next unit. And as we already talked about, inclusionary units can qualify a project to receive a density bonus. Okay, next slide. So how is this calculated? So first, a project needs to determine what is the base density. And for that, you would look at your property size and the zoning requirements for density. And from there, you can calculate how many densities would be allowed on the site without a density bonus. After that, the next step is to figure out how many units you will be providing at an affordability level and which affordability level. And that can help you figure out how much of a bonus the project is eligible for. If there's a secondary or a bonus density bonus, then you repeat those steps to figure out what that is. And then lastly, you take those together to calculate the final project density with all of the applicable density bonus units. Next slide. So there are certain jurisdictions that do not have zoning codes that lay out density on a dwelling units per acre basis. These other ones are typically form codes where it lays out the standards that a project needs to meet, and then that dictates how many units can be developed on a site. So for these particular jurisdictions and these particular sites, the way the density is calculated and figuring out how much of a density bonus is available would be to estimate the realistic development capacity of the site based on the objective development standards that are applicable to that particular project. A developer may provide their own study, which the city has to accept unless they're not complying with the objective standards that are required for that property. And so this determines what is the base density. Next slide. Okay, so that we have covered what is the basics of density bonus and how to calculate a density bonus and how much there is of an increased density. And at this time, we'll take a short break to answer any questions.
Thank you, Gabrielle. Yeah, that was a lot of information, a lot of numbers and calculations going on. I only see one question at the moment, which is about moderate income units and eligibility for density bonus for that income category. The question is, can rental projects qualify for density bonus with moderate income category units, or is that only for sale projects?
Let me quickly double check the statute. It used to be the case that it was only for sale projects, but I believe this was recently changed to allow rental projects as well. But
maybe we could go back in our slides. I think around slide 6 or 7, we may have had a table with information. So this might be coming from that. And if anyone else has...
Oh, that's right. Yes, that used to be an older requirement. Yeah. The statute now says, let's see. Well, it still says 10% of total dwelling units of a housing development are sold to persons and families of moderate income. So I believe that is still a requirement.
And so just to confirm, moderate income rental projects wouldn't be eligible for density bonus alone.
I believe that's the case. Yes.
Okay. All right. So hopefully we answered that question.
Except if we're in the 100% affordable category, which I believe those could be rented. So it's a bit confusing.
Yep, I see that. All right, and then here's another question we just got in. It's quite long. I'm going to read it as I try and make sense of it here, but what does an unlimited density bonus mean? For example, if a project is within a half mile of a major transit stop, can they propose any density and have it granted as a concession, or is it a blanket allowance of any density above the base density?
So if it is 100% affordable project within a half mile, and I apologize, I didn't hear if you said it was 100% affordable. Within a half mile, it can receive unlimited density. It's not required to be requested through a concession. The developer would just show up with their proposal of how dense they want the project to be.
All right. So let's leave it at that. That question does have some SB 79 parts attached to it, but I think we're going to try and table those for now. And if we need to get into that later, we may need to. But let's try and stick to density bonus and the core topics under that part of government code. I don't see any other questions, so let's continue with the presentation, Gabrielle, please.
Okay, so next we will talk about incentives, concessions, waivers, and reduction in parking standards. And I know that there's a lot of questions related to incentives, concessions, waivers, and there's a lot of confusion about what these terms mean and what the difference between them are. So incentives and concessions are used interchangeably in the statute. So I think that is part of what creates some confusion, is that we have two terms that mean the same thing. And this is a reduction in a site development standard or a modification of zoning code requirements, architectural designs, and also any other, concession of regulatory incentives that would result in an identifiable and actual cost reduction. So I tend to think of concessions and incentives as something that will reduce the cost of the project to provide for the affordable housing. A waiver is a reduction of development standards that will have the effect of physically precluding the construction of the development at the densities and with the incentives and concessions that were granted. So the way I think about it is waivers are related to the physical space of the building and the property in the project, and incentives and concessions are related to the cost of the project. Waivers are unlimited. A project can request as many as they want. Incentives and concessions are limited based on how much affordability is provided in the project. And we will go over that, I think, in the next slide. Okay, not the next slide, the one after. So first we'll go over what is the definition of a development standard, and that is a site or construction condition that applies to the residential development project pursuant to an ordinance, general plan element, specific plan, charter, or other local condition, law, policy, resolution, or regulation. So examples of these are height limitations, setback requirements, floor area ratio, open space requirements, both private and public, lot size requirements, parking requirements, etc. So this slide here lays out the number of concessions that a project might be entitled to. So if a project very low income, if a project provides 5% of the units at very low income, they are eligible for one concession. And this goes all the way up to a very low income project providing 16%, and they can receive 4 concessions. A lower income project that provides 100% affordability, this is the 80% low income plus 20% moderate income if they choose, is granted 5 concessions, and that's the greatest number of concessions possible. And this 5 concessions is a recent change. I think it came about in the past year or so. And the screen here lays out some additional requirements for other income categories and how many concessions those projects can receive. Next slide. There's some additional special incentive categories for certain projects that don't fall squarely into that prior table. So a student housing development project, if it provides 20% lower income units, it can receive 1 incentive or concession. If it provides 23% of lower income, and by unit, it's really more of a bed type situation. For lower income students, it can receive 2 incentives or concessions. And then, as I mentioned on the previous slide, projects that are 100% affordable can receive 5 incentives, and they're also eligible for a 3-story or 33 feet height increase if they're located near a major transit stop or VMT, a low vehicle mile traveled area. So a city or county can request reasonable documentation to establish the eligibility of a requested density bonus, incentives, concessions, waivers, or parking reductions. However, the city or county cannot impose additional requirements that are beyond what is necessary just to verify the eligibility for the project. Next slide. So if a city or county wanted to deny an incentive or a waiver, this is quite difficult to do. The city would need to demonstrate that the requested incentive or concession does not result in identifiable cost reductions, or that there would be an adverse impact on public health and safety, on real property that is listed in the California Register of Historic Resources, and that there is no feasible mitigation to address these impacts. Or if the requested incentive or concession is contrary to state or federal law, that would be another ground to deny it. Waivers are similar in that to deny a waiver, it needs to be shown that there's an adverse impact on public health and safety, or a real property that is listed on the register of the historic register, and that mitigation is not possible, or that the waiver would be contrary to state or federal law. Next slide. So we have a few cases from recent years that address density bonus law that are important to note, and I will provide a brief high-level summary of these cases. So Wolmer versus City of Berkeley is from 2011, and in this particular case, neighbors challenged a mixed-use, affordable, and senior housing project. The basis of this challenge was that because incentives, concessions, and waivers had been granted, the challengers argued that the project was no longer consistent with the city's development standards and zoning code and general plan, and therefore the project should not be eligible for a CEQA exemption. This particular project had been granted, I believe it was a Class 32 infill exemption. The court found that density bonus law should not be interpreted as requiring general plan amendment, zoning changes, or other discretionary approvals, and that the reasoning the city gave was that the waived standards were not applicable to the project, and therefore the project was consistent with the applicable standards for the project, and the court upheld the CEQA exemption on that ground. The next case is Schreiber versus City of Los Angeles, which came out about 5 years ago. And in this case, the neighbors challenged a mixed-use project that had been approved by the city. And the court talked about how density bonus law should be interpreted liberally to favor the production of the maximum number of total housing units. And there is now a provision in density bonus law that says this as well. The court found that, let's see. So in this particular case, the city's statute for the city's ordinance implementing density bonus law had a requirement that the project applicant needed to show that the requested incentive is necessary to make a project economically feasible. And I believe the city had some discussions and said that they could not require this, and that is what was being challenged. And the court found that an applicant for a project is not required to provide financial information to support an application for density bonus, and that the city cannot require that the project provide information that shows that the incentive is necessary to make the project economically feasible, and that the information that is needed for the city to be provided to the city is to establish eligibility for the concession or incentive and to demonstrate that it meets the definitions in the statute. So requiring documentation for economic feasibility of providing the project cannot be requested by a city. And the last case is out of the city of San Diego, and this is the Bankers Hill case. In this case, a city had approved an application for a 20-story mixed-use building with a little over 200 dwelling units. A neighboring community association challenged that approval because they believed the project was inconsistent with the neighborhood. It was too dense, too tall, and too close to the street. So the court found that the city has to offer the waiver or reduction of development standards that would have the effect of physically precluding the construction of the development at the density it's allowed to be, and with the requested incentives that are permitted under density bonus law. There are very limited exceptions where a city can deny a requested incentive or waiver, and density bonus law places the burden on the city to establish that they cannot grant that requested waiver or incentive. And then the court reiterated the standards for denying an incentive, concession and waiver, which we just went over. And it also stated that density bonus law does not require a developer to establish that the requested incentives and waivers are necessary to ensure financial feasibility of the project. So in closing, so long as the proposed housing development project meets the criteria of density bonus law by including the necessary affordable units, a city cannot apply development standards that would physically preclude construction of that project as designed, even if the building includes amenities that are beyond the bare minimum of the building components. So this is to say a city cannot require a project be redesigned or that amenities be taken out of a project in order to comply with the standards in the code when they have requested a waiver or an incentive or concession. So those are some 3 important cases to be aware of. Next slide. Okay, so with that, we will move on to reduced parking ratios. The density bonus law provides for a reduction in the required parking for a project, and this needs to be requested by the developer. A 0 to 1 bedroom unit in a project is only required to provide 1 on-site parking space. A 2 to 3 bedroom unit is only required to provide 1.5 on-site parking space, and a unit with 4 or more bedrooms must provide 2.5 on-site parking spaces. These reduced ratios apply to both the affordable units that are being provided as well as the market rate units. And there are some additional parking reductions when a project is located within a half mile of a major transit station. Next slide. Okay, so that is our overview of concessions, waivers, and parking reductions. And we'll now take questions.
We do have a few questions. I'm excited, Gabrielle. I'm in Bakers Hill. I can see the building that was the subject of that case here in Bakers Hill versus the city of San Diego. They tried to waive a little courtyard to support the commercial. It's very active all day long with a little cafe. So I always get excited when the subject of our material in these webinars, something I know and familiar with. So let's go to the questions here. Can concessions and waivers be used to waive general plan requirements? And in particular, mixed use or retail requirements as part of the project? Can those be waived?
Yes, those can be. Typically, that would be done through a concession, not through a waiver, because that is more of a deviation of a zoning code requirement or an other regulation, not necessarily a development standard. And I will point out that HCD provides technical advisory letters to jurisdictions. Either jurisdictions have written in with the question, or a jurisdiction is proposing or leaning towards doing something, and the developer wants support for challenging that. And related to this particular questions about retail and mixed use components, they have written at least a couple letters to jurisdictions saying that that is something that can be deviated from with a concession.
And to the general plan piece, it really doesn't matter where that standard lives as long as it's an objective standard being applied to the project, right?
Exactly. Though I would point out, what the purpose of the general plan standard is might be worth looking at. For example, if it's something related to public health and safety, then that might be a reason to potentially deny a request for a waiver or a concession. So I think the standard itself needs to be looked at.
All right.
But
Thank
yes,
you.
the location of where it is does not matter.
Yep. Next question is, does a developer need to demonstrate the need for a concession? Did any of the cases we mentioned or other cases deal with that, and what is needed to demonstrate that?
I think generally as part of the application, they will explain why they qualify for a concession. And it will potentially be something as simple as this will reduce the cost of construction, which is needed to provide the affordable housing. What the developer provides can be pretty general. if the city wanted to go down the rabbit hole of seeing if they could deny such a request, the burden is on the city to demonstrate. So potentially the city would need to look into what it might take to refute the developer's request, or potentially an economic or finance study demonstrating that it would not actually reduce the costs of the project.
All right. And then a question about parking reduction granted through density bonus law. Is the parking reduction granted at the request, or is it one of the incentives allowable?
It is at the request, but it does not use up one of the incentives, if that makes sense. A developer could request further reduction in the parking requirements through a waiver, for example. I guess if they wanted to request it as an incentive, they could as well. So what's in the code is granted upon request. It does not use up your concessions, incentives, waivers, but further reductions could.
All right, and I think that answers our next question as well. Can you provide some examples of what is not allowed as an incentive? The examples provided in the question are building code, health and safety requirements, those types of things.
Yes, those types of things. So, for example, if a city has some architectural requirements that go beyond what is in the state building code, that could be a request for a waiver or an incentive to not comply with. However, what is in the state building code must be complied with because that is a state standard. And if we look at our reasons that we can rely on to deny a waiver or incentive or concession, one of them is that the request is contrary to state or federal law. So not complying with aspects of the state building code would be contrary to state law. I don't know that I have specific examples, but the ones that were given, I think, work.
What about public improvements, like public works requirements tied to the project conditions?
I think that would depend on what the request is. For example, if a request is for a waiver of like putting in a sewer connection, I think a city could make a health and safety argument that a sewer connection is would be contrary to public health and safety. Like, what would you do with the sewer waste at that point? So I think that would really be dependent on what the specific requirement is.
Okay. Can an applicant request one waiver for multiple development standards under a zoning district, or does the applicant have to request one waiver for each development standard?
Well, waivers are unlimited, so I don't see the harm in asking for multiple waivers. And I think this is somewhere where jurisdictions treat things differently. So one jurisdiction might say one waiver for all setbacks. A different jurisdiction might say you need a separate waiver for each side of the property that deals with setbacks. So I think that is probably more of a jurisdiction by jurisdiction. But in the end, since waivers are unlimited, I don't think that ultimately makes a big difference.
All right, I'm going to do this question asker a favor and switch to incentives instead of waivers. How do you handle it? Do you
Yep, I think
do
that is
different?
more tricky. I think probably the least risky approach, and we're talking about risk in the sense of potentially receiving a lawsuit or a letter from HCD or the Attorney General. I think requesting an incentive to not comply with setbacks as opposed to using three incentives to not comply with setbacks, I think is probably a safer route for a jurisdiction. But again, that would be a question on how, precedent, how things are typically done in the jurisdiction, yeah, that's how I would look at it.
Yep. All right. And if a local jurisdiction has parking maximums, not minimums, which parking requirements are required? Those in state density bonus law or the local jurisdiction? So I'm assuming
So
the maximum would be higher than
then,
density bonus
yeah,
law
or the
ratio.
maximum would be lower than what density bonus law requires.
Yeah.
Typically, if there is a conflict between a local requirement and a state requirement, you would comply with the state requirement. So in this case, I would say comply with what's in density bonus law. And of course, a waiver can always be requested to change the parking standards.
Yeah, that's an interesting one. All right. Now we've got a question on the relationship of density bonus law and AB 2097 and parking reductions under that bill. If no parking is required for the site through AB 2097, can reductions in parking standards, aisle widths, parking space dimensions for parking spaces provided voluntarily be considered a waiver slash physically preclude the development if no parking is technically required for the site? Or would it be an incentive slash concession?
Oh my goodness, that was a complicated question. Okay, remind me, AB 27, is that the no?
2097, which is no parking required within a half mile of major transit stop.
Okay, so the state says that the public agency shall not impose or enforce minimums. It does not say that no parking is allowed to be provided. Um, so then the question was if the project wants to provide parking.
Yeah, and then they're not following the design standards for those parking stalls, it sounds like.
Then I think a waiver would be an appropriate request at that point to design the parking spaces, different than what is in the local zoning code.
Okay. Hopefully that answers the question. Uh, We're getting follow-up questions to the questions we've already answered, but this one goes
Okay.
back to the general plan requirements for retail. If the city, if it's tied to health and safety, in theory, the city could deny the concession to not include retail. But I think we've talked about the burden of proof is pretty high for that in general. But in theory, yes, it's possible. Is that true?
That's right. Yeah. If there's a health and safety reason why that's in there, you would need to point to that specifically, and explain. I'm not envisioning why there's a health and safety requirement to a retail component of a project, but perhaps there is, and that's what you would need to point to.
Yeah, I could think of like if you are in a flood zone where you're not allowed to do residential on the ground floor, you might not be able to waive that requirement. I don't know. I guess that would be the opposite of trying to put residential there. So,
Right.
um,
Right.
all right, going back, if a local jurisdiction has a maximum of 0.7, this one's pretty in the weeds. Um, Can a waiver be used to provide more parking than what the maximum is allowed in the jurisdiction with parking maximum? So this is a follow-up from the previous question.
Yeah, I mean, I would think so because you're requesting a deviation from the local design standards through a waiver, local development standards. So yeah.
Is the economic health of a city considered a health and safety issue?
Um, I think that is a question that probably we need to look at the fact specific, around what is happening in that city, what their codes say, etc. So I don't think there is a straight cut answer to that.
Yep. All right. I think we got to the end of our questions on waivers and concessions, incentives and parking. We do have a question about calculations, if we have time to go back and kind of just go over that again, which I think that we will.
Yep.
We got one more question here. Um, are architectural design requirements an example of an incentive concession or a waiver?
I think that would depend on what it is, how it comes in, how it would impact the project. So I think that would be a very fact-specific analysis that needs to be done if that would come in as a waiver or a concession.
Right. And just because it's objective design standards and deals with architectural, it could be financially related as an incentive or physically related to a waiver. So I think it does depend. All right. Any other questions on incentives, concessions, waivers, or parking? Not seeing any at this point. We can keep going, and if any others come up, we'll be sure to try and answer them.
Yes, we do have another Q&A at the end, so if more questions pop up that are not related to implementation considerations but are are related to what we've already discussed, please do ask those questions.
All right. Well,
So we're now at the last portion of the density bonus discussion, and this is some implementation considerations. I think we'll get through this fairly quickly. So just some notes about administration of a density bonus program at the local level. So planning applications for housing projects are required to have a standardized application or checklist, and this is important for when reviewing the projects to ensure that all the information has been provided. So if a jurisdiction does not have anything related to density bonus on their application standard, it would probably be a good idea to include that in your checklist. And to make sure that the jurisdiction is requesting the information that will be needed to properly analyze the project and know what concessions, waivers, or increased density are being requested. As we talked about with the Wolmer case, the density bonus deviations from standards does not result in a project being considered inconsistent with applicable standards. So when we get to the California Environmental Quality Act, a lot of times there's a requirement that the project be consistent. So this would not be something that kicks out the consistency. And no additional reports or studies should be required for a density bonus application. And the one exception to that is when we're looking at those form-based codes that don't have a clear dwelling unit per acre standard, a developer can provide a base density study. And I believe it's a voluntary thing. It's something if they want to provide it, they can, but not required to provide it. Though it might be in their interest to show that they can have more units than what a city might consider. Next slide. So in terms of long-term affordability, a regulatory agreement, it's not a requirement in state density bonus law, but it is a good way for a jurisdiction to ensure that the affordability continues, because that is a requirement on the city or counties to ensure that continued affordability. The regulatory agreement is a typical method of ensuring that that affordability continues. It's recorded on title so everyone knows about it, and it's a document that can be pointed to if for some reason the affordable units are no longer being provided. This applies to rental units, as we mentioned earlier, not to for sale units. And typically, these agreements will have information on how eligibility is determined, how rent is determined, a requirement for an annual certification to make sure that those units are still being provided at the affordability levels that they're supposed to be provided. And then there's also a requirement for a 55-year term for the regulatory agreement. Next slide. In the agreements related to units that are being sold, in this case, we have what is called an equity sharing agreement, and it provides requirements for resale of the unit. This may vary by jurisdiction. State law only provides that there's an equity share when the unit is resold. A lot of jurisdictions will expand on that in their local codes and require that a unit be resold to another eligible buyer, for example. But generally, a seller will retain the value of improvements. So if they make some capital improvements to the property, they typically can retain that value. A lot of times, a jurisdiction will request notification or to approve capital improvements of a certain dollar threshold. The seller would retain their down payment, and then appreciation of the property value is shared with the city or county. Typically, the home buyer documents that go along with these units are an equity share agreement or resale restriction agreement, depending on what the local codes require. And that's what we just went over. There may be a promissory note as a way to ensure that the local jurisdiction does receive their share of the appreciation, and then a deed of trust for that exact purpose as well. Next slide. And then some CEQA considerations that I think we have already talked about. There is no specific exemption for density bonus, but there certainly can be a lot of other exemptions that might apply to a project. For example, the categorical urban infill or the new AB 130 statutory urban infill exemption may apply. And then there's a few others related to affordable housing or projects near major transit stops. A project is still considered consistent with objective standards, even if they have received a density bonus or concessions or waivers. So it can still be eligible for exemptions that might require general plan and zoning conformance. And then one other caveat, though, is if a project is not eligible for a concession and it is relying on a previous EIR, environmental impact report, that was potentially done for a specific plan, the zoning code, a prior project proposed on the site, the general plan, there may be issues with what density was studied in that particular environmental impact report and what density is being proposed on the project site. So that's just something to keep in the back of your mind if the project is not eligible for an exemption and intends to streamline and tier off of a prior EIR, it will be important to look at the EIR and make sure that it studied the appropriate densities for the project. Next slide. Okay, and we are at the end of the presentation, and so now we will take some more questions.
Yep, we do have a couple that kind of go back to calculations and incentives. But the first one is if a project qualifies for a density bonus, incentives, concessions, and waivers, and the project includes accessory dwelling units, can they use those incentives and waivers towards the ADUs?
I would think so if it's the overall project and appropriate affordability is being provided in the overall project, then I would think yes.
All right. Can a local agency require a density bonus report as part of the application for density bonus?
I think that depends on what that report is intended to do. If it's merely we're requesting increased density in the following concessions and waivers, then I think yes. If it is asking for a detailed financial analysis of the project, then I think no.
And it could also include a base density study as well, right?
That's right, yes.
Hopefully that answered that question. And this is a repeat question, but can an applicant request one incentive concession for multiple development standards? And I think your answer before was kind of depends on precedent from that jurisdiction. If that's something you typically do, you may be able to do that. But it kind of depends jurisdiction to jurisdiction, right?
Yeah, and I think it would depend on the standard and how it's being applied, what it is. I think that would also impact the answer.
All right. All right. I think that's all the other questions for now. I think we have some concluding slides, but we do have some additional time if anyone has any questions. I think we've heard a lot of questions that are getting more and more specific to certain projects, jurisdictions, and situations. But I don't know if anyone has more questions or wants to talk more about their experiences. There is more questions in here. So I just will note real quick, saw a couple questions come in about recordings and slides. This presentation is being recorded. We will make the recording available as well as the slides. And I will note as well, SANDAG is working on a publication kind of as a companion to this webinar to be a primer on density bonus law requirements as well. So just wanted to let you all know that is coming. Let's go back to the questions here. This is more of a comment about equity sharing, but I think the comment here is that equity sharing agreements are not the only mechanism, but they can also be sold to nonprofits. So I think this was mostly an FYI and wanting to share that as a pathway as well.
Thank you for pointing that out. I did leave that out of the presentation, but yes, that is another pathway for those for sale units is to sell them to, and I believe the statute lays out specific requirements that the nonprofit needs to meet to be able to purchase it. And there is also a newer requirement that I think came about last year, that if one of those units is not being sold for whatever reason, potentially there are no eligible buyers, that it should then be sold to a nonprofit. So that's also a newer thing in the statute. So thank you for bringing that up.
Yeah. And I think one other part of that question is any of the documentation specific to selling to a nonprofit different, or would you recommend anything specific in that instance in terms of documentation required?
I think that is going to vary by jurisdiction, by project. But you know, potentially you're selling to a nonprofit to have them sell to another eligible buyer or to have them rent to an eligible household. So I think in those cases you would need to figure out what is the intent of the purchase and tailor the documentation to that.
Thank you. This is one more question here. Could you elaborate a bit more on what is meant by eligible for exemptions that require general plan and zoning conformance?
I'm not sure I'm following
Maybe go back to
the question.
the previous slide. I think this was in response to that.
Oh, this one.
Second bullet, yeah.
Yeah, so I mean, we're basically saying, for example, if you, and I'm just going to stick with my setback example because that's an easy one. If you deviate from the setback, for example, your setback is 5 feet and your project only provides a 3-foot setback, that is not a reason to kick you out of a CEQA exemption. That is not a reason to say the project is not consistent with the zoning code, and therefore you cannot rely on the CEQA exemption, or even if you need to do further analysis like an EIR, that you wouldn't say the project is not consistent with the zoning codes because of this deviation. So hopefully that answers the question.
Yeah, hopefully, and feel free to let us know if it has not. In regards to justifying an incentive or concession request, what can a jurisdiction ask for as support? In other words, what would be considered reasonable documentation? And I'm gonna guess your answer here, Gabrielle, is it depends.
Yep. Yep. That's my standard lawyer answer. It depends on the facts. It will potentially be different. I think in the past, jurisdictions would ask for a pro forma, for example, the financial analysis. I can tell you that that's no longer allowed, so don't ask for the financial projections of the project. I think some jurisdictions are comfortable accepting like an invoice from a contractor saying this is going to cut off $10,000 to the project or whatever it is. So I think it varies by jurisdiction and it varies by the request.
Thank you. All right. We've gotten through most of the questions, except for one we got very early on, which was to go back and review the calculations at some point. So maybe we could go back to that first section and look at some of the calculations and just review that module if you don't mind.
Sure.
Rebecca, if you can get us to the right slide. Yeah, I don't know if this is a good place to look or if some of the specific numbers might be more helpful.
Yeah, maybe we can go back to the table with the numbers. So I don't know if this is what the question that wanted to review the specific calculations. This is a summary, and the exact numbers are included in the density bonus statute. So for example, the statute will have a column saying, here's the percentage of the project with low income units, and then next to it will be a column that says, here's the percentage of density bonus increase you receive. And in this case, we have summarized it to take up less space on the slide. But was there a question specific about this calculation that we could?
I'm not sure, and I invite the question asker to unmute themselves if that's a preferred method to get the question answered.
Hello, this is Christina Bustamante, Senior Planner with the City of Encinitas. I was the one who sent the question. I think I was just trying to understand the numbers that were being given and how they fit together. I think we kind of started to walk through if this, then that, but I don't think we did an exact calculation. Is that correct? It was more of just generally broad. This is how you walk through the process. Is that correct?
Yes, that's right.
Yeah. Okay.
Yes. So on this particular table, for example, if a project were to provide 10% of the project to lower income households, they would be eligible for a 20% bonus. And then we, instead of laying out the rest of the numbers, we say if you go up by 1.5%, so then you'd have 11.5%, or sorry, you'd have 11%, you would then get a 1.5% increase in your bonus. And then we just targeted two other categories of bonus increases, but we did not walk through a specific scenario.
Okay, I think maybe if you don't mind, the portion here which says additional bonus for 1% increase, does that mean like, say for example, in very low income and it has 5%, if they were to go to 6%, then they would have this additional 2.5? Is that how?
Yeah, that's right. Yeah. So if a project provides 6% of the units at very low income, they would be eligible for a 22.5% bonus.
Got it. And so is that intended to bridge the gap between amounts in that table? So like it goes 5, 10, and so forth. So like, is this 1% increase trying to make up each one of those things? So like you could calculate how much additional bonus you could have,
Yes.
like in between.
Yep.
I see. Okay.
Yep. And to save space on the slide, because the statute does lay it out specifically. So the statute will say if you provide 12% very low income, you can receive 38.75% of a density bonus increase. So it was a space-saving mechanism on the slide.
I got it. Okay. Thank you.
Thanks for helping us get your question answered. Any other questions? Anybody, I'm afraid to say this, but I'm going to say it anyways. Anybody else want to talk about their experience with density bonus or things they're struggling with? I think we all struggle with trying to do good planning with density bonus, and that's reflected, I think, in a lot of the questions and frustrations in trying to shape projects, but inviting anyone who feels an urgent need to share. All right. If nothing else, let's keep going and we can start to wrap up with some reminders and conclusions. So first, I mentioned we are working on a density bonus law publication that gives an overview. We are looking to include kind of a typical project example, so that might help with some of the calculation examples going on there. In addition to that, for the SANDAG member agencies, we are still working on local staffing assistance requests. So if you have additional needs we may be able to support related to density bonus law or other things related to housing, please reach out and let us know what your needs are, and we can talk about how we might be able to help. If you have any inquiries, please reach out to housing@sandag.org, and we can go from there and kind of work on scoping any requests. I know we've worked with many jurisdictions already, and we are taking additional requests. So reach out if you have any needs. A reminder, annual progress reports are due to HCD on April 1st. We have the last of our office hours for annual progress report assistance for SANDAG tomorrow at 11 a.m. I believe we'll send out a reminder with a link if you have any last minute burning questions on your APR before you're wrapping that up and sending it off. And then HCD does have office hours as well on Friday that they will be hosting. So just a reminder on those technical assistance opportunities. If you have any other questions about SANDAG's TA program, visit sandag.org/housing. For local staffing assistance requests or other needs, please reach out to housing@sandag.org. And I will turn it over to you, Carrie, for any other final messages you'd like to share.
Nothing else from me except thank you to Matt and Gabrielle for hosting and leading such a great presentation, and thank you for everybody joining us today.
Yeah, huge thanks to Gabrielle for being a sport and answering all those questions in a live setting and doing your best to get helpful information. We really appreciate it, and great job. So I'll give you a round of applause here. So thank you, Gabrielle. If nothing else, I think we can wrap up a few minutes early and thank everyone for attending. And again, thank you, Gabrielle, for your helpful presentation today.
And thank you for having me. It was my pleasure to talk about density bonus with all of you.
All right. Thank you, everyone.
Thank you.